Very good evening to all of you friends. A very good evening to all of you. I'm sure that you guys were eagerly waiting for this particular session to happen because we are discussing today the most expected questions for legal aptitude insofar as your Maharashtra CET examination is concerned. We bring to you in this particular round a certain number of topics, certain number of questions which are absolutely important, relevant insofar as your Maharashtra CET examination is concerned. So guys, before we begin, please share this session so that more students can join this particular session that we are conducting from BYJU'S exam prep. Now, before we get into the topics that we are going to talk about, we will talk about partnership, we are going to talk about divorce, we are going to talk about private defense, act of God, culpable homicide, murder, wagering agreement. So there are a host of topics that we shall be discussing in the course of this particular session today. So a very good evening to all of you. So we have I can see Aditya Mishra, Pallavi, Tejaswi, Kulsum. Very good to see you guys. Fantastic to see you. Great. So with this introductory lines, let's begin. Now before I begin, I would want to discuss with you certain very important aspect. Now you are preparing for Maharashtra CET. Now, the kind of questions that come in this particular entrance examination is little different from those what are asked in CLAT or AILET. Now, CLAT and AILET are at a different footing and Maharashtra CET is at a different footing. So, before you sit for an exam, you should know what are you expecting from the examiner. That's very important. That is very important for you, because unless and until you understand the mindset of the examiner, how will you prepare for an examination? Now, CLAT has this passage based questions. I'm sure you guys all know it. AILET has a different kind of a structure and Maharashtra CET has a different kind of a setup. Now, Maharashtra CET, you have principle and fact based questions which are commonly asked. Apart from that, they also ask you questions on legal knowledge. Legal knowledge, who is the Solicitor General of India, who is the Attorney General of India, who is the Chief Justice of India, who is the Chairman of the National Green Tribunal, who is the Chairperson of the National Human Rights Commission. So you will be expecting these kind of questions to come in your examination. Now today, what we shall be precisely trying to do in this particular session is simply to understand a couple of topics like dowry death, partnership, wagering agreement, and we are going to understand the concept as well as we are going to solve certain questions relating to those concepts. So we bring to you in this session something that is very important for you. So let's get started. Let's get started, friends. Okay. Now the first topic that I'm going to talk to you about, okay, is the concept of partnership. Now, what is partnership? First, let's understand the concept of partnership. Now, what is a partnership? Some of you might be BCom students, accountancy. Those people might be familiar with the term. Some people who are art students or science background students might not have those typical idea. But let me tell you, what is partnership? Now, suppose partnership is this beautiful concept whereby two or more than two people, when two or more than two people enter into an agreement, what do? They enter into an agreement whereby they can, whereby they want to sell something in the market. Partnership is a concept where more than one people, two or more than two people, enter into a contract, enter into an agreement whereby they decide that they are going to sell something in the market, they are going to earn profit out of it, and they are going to share the profits and losses of the business. Very simple. So when you and your friend decide that you guys are going to do a particular business, for example, selling sarees. Suppose you and 5 of you want to do a business of selling sarees. Very well. And you decide that whatever will be the profits, we are going to share it. Whatever be the losses, we are going to share it. That is this concept called partnership. Am I clear to everyone? Is that clear to each and everyone out there? Okay. Now let's understand certain very important facets. Okay. Now, partnership, the law relating to partnership is governed by the Partnership Act of 1932. So we have a Partnership Act of 1932 which deals with the rules, regulations relating to partnership in India. Now, under this provision, what is given? Provision for admission of a new partner in a partnership. Suppose there are 5 partners. Initially, there were 5 people who sat together and they want to do a business. Now, addition of a 6th partner, how is that possible? It states, let's read, very important. It states that a new partner can be admitted with the consent, with the approval of the existing partners in the firm. So if there are 5 original partners, the 6th can be added with the consent or approval of the original 5. Am I clear? Is that clear? Now, let's see. Let's read a principle. And let's understand, okay? Here is a principle. I have explained you this principle. Read the principle carefully, read the facts carefully, and there will be certain options, okay? Your time to read the facts, understand it, and give me the right answer. A, B, C, D are partners, and they in their partnership deed agreed that A is authorized to admit his son S. Okay, so A is authorized to admit his son S in the partnership when S, the son, attains 18 years of age. A nominated S on a partner and S agreed to become a partner. But B, C and D refuse to recognize S as a partner. What does the principle say? Partners can be introduced into the firm only with the consent of the existing partners. So, have the existing partners agreed? Has the existing partners agreed that S can be a partner in that firm? Tell me. These are the options. I'll come with the 2 more options. Read the four options very, very carefully and tell me what is the correct answer. B. S is not a partner in the firm since 3/4 of the partners are against S becoming a partner. 3/4. Okay. Read option C, read option D, and give me the right answer. Give me the right perspective of the answer. Okay, now everyone has started saying option D. S will become a partner of the firm. Do you think so? They all agreed that A is authorized to admit his son S into partnership. Very important. Very, very important. They all agreed initially that S can be admitted at the age of 18. Right? So all of you are saying option D. Let's see. Option D is the right answer. Originally, all four accepted and consented that S can be a partner once he attains the age of 18. They had all accepted it, haven't they? They all accepted this particular thing. Am I clear to each and everyone? Have I made myself clear to each and everyone? Is that clear? Any doubt? So, if you are liking this session, what prevents you from liking the session, guys? So, do like and share. Moving on. Okay. Now, the next concept that we are going to talk is called the concept of divorce. This is family law. Now, family law, questions from family law has come on a number of occasions in CLAT, AILET, Maharashtra CET. Now, what is this concept of divorce? Wait. What is this concept of divorce that we are talking about now? Now, marriage, divorce, depends on the religion a person follows. That's why it is called family law. Now, what is this? It depends on religion. Now, Hindus have different methods or different rules, different regulation of marriage. A person following Islam has different rules relating to marriage. A Parsi, a Christian, they all have their own rules and regulation relating to marriage, right? Now, here we are talking about Hindus, Hindu Marriage Act. Now, this Hindu Marriage Act categorically says that a marriage is nothing but an union of two souls. Muslim law says it in a different way. Rules are different. So, under this particular law, divorce that we are talking about, what does it say? It says that cruelty, if the husband is being cruel to the wife, if the wife is cruel to the husband, the term cruelty, I'm sure you understand, it can be a reason for asking for a divorce. So, cruelty happens to be a reason, happens to be a ground or reason for asking for a divorce. Now, this is provided under section 13. You guys need not know it. But you should know that under the Hindu Marriage Act of 1955, under the Hindu Marriage Act of 1955, there is an explicit provision that cruelty can be a ground for separation. Let's see. What does 13A subclause 1 say? 1 subclause A say? Any marriage solemnized before or after the commencement of the Hindu Marriage Act of 1955 on a petition present by either of the spouse. So either the husband can go to the court or the wife can go to the court. So this is equal. It's not that only wife can go to the court or only the husband can go to. So this is a gender neutral provision. May on a petition presented by either of the spouse be dissolved by a decree of divorce on the ground that the other party has treated the petitioner with cruelty. So cruelty is a particular ground for getting a divorce, for separation. Is that clear? All of you? All of you? Any doubt? Okay. Landmark cases. Don't have to remember the name. It form the conduct of the spouse, either the husband or the wife, and interference. Now, spouse and inference can be legitimately drawn that the treatment of such nature that is caused apprehension in the mind of the other spouse about his or her mental welfare. Now, if there is a situation where the husband or the wife is going through some mental pressure, there is an apprehension of a cause of a problem of mental health issue, that can be a ground of cruelty. That amounts to cruelty. Now, suppose a husband is saying something bad to the wife, not beating. Do not always think that, sir, the husband has not slapped the wife. No. Mental cruelty. If you are torturing, not physical torture, mentally if you are torturing, that is what is said. Have I made myself clear? All of you? Is that clear? Another case. Okay. What happened? Wife making false allegation. When the wife has made certain false allegation against the husband of having an illicit relationship, extramarital affairs. Now, if the wife tomorrow tells the husband that you have an extramarital affairs, you have a bad character, something like that, and if it is false, that too amounts to cruelty. Have I made myself clear? So even that would also amount to cruelty under the Hindu Marriage Act. Is that clear? You understand what is cruelty now? All of you? Any doubt? Another two cases. Cruelty includes such acts which may cause mental agony. Now, please, I request everyone who is listening to me right now, mental cruelty is also a ground. It is not only talking about physical cruelty. In another case, the court said that solitary instance of cruelty would not constitute cruelty for divorce. Rather, the behavior has to be persistent and repeated treatment with cruelty. Now, in a husband and wife relation, there can be ups and downs. There can be alteration. There can be a fight. People have. That is not cruelty. Now, you might not agree with your husband. You might not agree with your wife. It's fair. But cruelty is not that. Cruelty has to be persistent in nature. It has to be continuous effect of it. Once in a blue moon, there is an alteration between the husband and the wife. There is a fight between the husband and the wife. That is not cruelty, because that wear and tear happens in daily lives. Is that clear? So, this is what the law is. Have I made myself clear? Every one of you? Okay? Okay? Moving on. The next question is up there on your screen. Read the principle very carefully. I have made you understand what is cruelty. Apply, read the principle, read the facts, and tell me the correct answer. Now the question over here is, has the husband done it once in a blue moon, or is it something that is continuously happening? Now the answer is only in these two words. A would on many occasion. On many occasion. Those are the two catchwords. Now, when you are answering a question, you have to pick those catchy words. On many occasions, on many occasions. Fantastic. So, what is the correct answer? Option D. B is entitled to a divorce. This is what is amounting to cruelty over here. A persistent in nature. Something that is happening on a regular basis. That. So the correct answer over here happens to be option D. Okay? Everyone, are you understanding? Have you all understood it? Any doubts? Okay. Okay, I'm really sorry. Yeah. Okay, so the correct answer is option D. Let's see. Apprehension towards causing pain, causing threat also amounts to cruelty. The apprehension. Okay, all of you, are we done with this? The next topic, gift. What is a gift? What is a gift? Now suppose I own a mobile phone and I want to give it to someone without any consideration. Now, if I am selling it to someone, it is not a gift. Then what is a gift? Gift is a situation. Gift happens to be a situation wherein you are giving something without expecting the other person to do something in return. You are doing something you are expecting zero. Is that clear, all of you? So, suppose you want to give something, you can give. Suppose you have 100 rupee note, you want to give it to Mr. A, you can give it. Who is stopping you? It's your money. Let's see. Now, gift is a transfer of property. This is my mobile phone. I am gifting my mobile phone to Mr. A. So, this particular property which originally belongs to me from now will not belong to me. There will be a transfer of this particular property. So, we have the Transfer of Property Act of 1882, British times, which deals with transfer of property in India. Am I clear? What does it say? As transfer of certain existing movable or immovable property made voluntarily and without consideration. So there is no consideration by one person called the donor to another called the donee. So if I am giving this mobile phone to someone else, I become the donor. To whom this mobile phone is given is the donee, and accepted by or on behalf of the donee. So this is accepted. Hence, important ingredients of a gift are that existence of a movable or an immovable property. What are you giving? Some property. It has to be in existence. Transfer to be made voluntarily without consideration. Transfer to be made by the donor. Acceptance of transfer to be made on behalf of the donee. So somebody is giving, somebody is taking movable, immovable goods, and there is no consideration involved. Okay, is that clear? Is that clear, all of you? Okay, Now, such acceptance of the gift must be made by the donee during the lifetime of the donor and while he is still capable of giving or transferring. So, the person who is giving should be in a position where he is giving it to an actual person. Before it is accepted, the gift is rendered void. Okay. Hence, the important ingredients of acceptance are: acceptance can only be made by or on behalf of the donee, acceptance can be made or during the lifetime of the donor, acceptance can only be made while donors still capable of giving. So these are the most important ingredients of what? Gift. Let's read the principle and let's see. So the principle finishes over here. There is a fact that comes from here. Okay, there's a small, yeah, please. Now the father wants to gift a particular property to his son, but there is a particular clause which says that only after the father dies, the gift will be made effectuated. The son says, I am not getting into all these things. I don't want anything. And finally, the father gives that property to Mr. C. Which of the following is the correct answer? Is the gift which is made by A to C, is it valid? Is it valid? Whether the gift that is given to C, whether that particular gift is valid or whether it is invalid. That's a particular question. Most of you have given me the right answer. The correct answer is option B. The correct answer is option B. Am I clear? Is that clear, all of you? Is that clear to each and every one? Okay. Is that clear to each and every one? Okay. So the correct answer happens to be option B. Any doubt? Okay. That's the answer. Okay, let's move on. The next concept, private defense. Now, what does private defense mean? What do you understand by private defense? Now, what are defenses? These are nothing but excuses. Now, suppose you have been charged under a particular provision of law. What are those arguments? What are those reasons that you can give in the court of law to tell the judge that you are not the wrongdoer? Now, suppose there is an allegation against Mr. A that he has committed trespass. Now, what are those arguments that he can use in the court to show that he is not the wrongdoer? That is precisely what we mean by defenses. Now, please try to understand that in law of tort as well as in criminal law, there are certain defenses. Now today, in this particular slide, I am going to talk to you about the defense under criminal law. Now, suppose I'll give you an example. Now, suppose somebody has aimed his gun at you. Somebody has aimed his gun at you. His forefinger is on the trigger. there is a forefinger which is on the trigger, it's a loaded gun. What are you going to do? Are you going to say, hey guys, please wait, let me call the cops, let the cops come, wait for 5 minutes, don't shoot? Will you say that? Will you say that? Will you say that? No, you will not say that. What will you do? You will try to protect yourself. You are going to try to protect yourself. Against what? Against that harm. There is a harm that is coming on you. Somebody is aiming his gun at you. All you need to do is to protect yourself, is to defend yourself. That is precisely what this particular principle of private defense is. The law simply says that in case there is a threat, on your body or your property, you can use reasonable force. All you can do is you use reasonable force to prevent that danger from being inflicted on you. Have I made myself clear? Have I made myself clear? So in case there is a threat on you, somebody has a stick in his hand, he is about to beat you, you have a right to defend yourself. You can pick up a stone and throw it at him. Right. That is what a normal human being would do. Somebody is coming with a sword in his hand. What do I do? To protect myself, I pick up a huge stone and throw at him. That is what generally normally people will do. This is what we call as the concept of private defense. Let's see. It is not an offense. It is not an offense if it is done in the exercise of right of private defense. So if you are exercising the right of private defense, mind you, if you are exercising the right of private defense, nothing is wrong. Forget the sections. The right extends to even taking someone else's life. Okay, the right extends to defending one's body, property, body or property or body of the others, property of the others. Now, this particular right, private defense, deals with acts against which there is no right of private defense. So, there cannot be a private defense against private defense. There cannot be a situation where you are using private defense against someone who is himself using private defense. For example, suppose I have aimed my gun at Mr. A. Now, Mr. A suddenly throws a knife at me. Now, I cannot say that I am shooting Mr. B because of private defense. I cannot say that because I was the one against whom private defense is used. That is the concept. That is what precisely this concept is. It states no right of private defense is available against an act not causing reasonable apprehension of death or of grievous hurt if it is done or attempted to be done by a public servant. Now, if a police or a military or the Air Force, Indian Navy is doing something, there cannot be a private defense because they are the authorized servants of the government of India. Okay, so that is what precisely this particular thing deals with. Have I made myself clear? These are the very, very important things, guys. Note it down. Okay. Question is up there on your screen. The question is up there on your screen. Okay. Now, somebody is coming angrily. Does it mean you take out your pistol and shoot him? Suppose you find someone pretty angry. Suppose a person is walking very angrily and 5 days back you had a fight with him. Just because he is walking angrily, does it mean that you take out your gun and shoot him? Doesn't happen. Doesn't happen. So is he entitled to that private defense of shooting someone? No. So the correct answer is option A. Option A happens to be the right answer. Option A happens to be the right answer. Is that clear to each and every one of you? Okay. Okay. Everyone? Is that clear? Okay. Private defense only exists when the act caused a fear of death or grievous hurt to the recipient. Where was that? There was no apprehension of a threat. There was no threat. There was no threat in the first place. Since there was no threat in the first place, how can you use private defense? Simple. And that's why we say when we conduct our live classes that please understand these principles. Now, while we are discussing with all these things, let me tell you, because a lot of people would want to know that, guys, those who are watching this particular session in our YouTube platform, requesting all of you that there are a huge amount of good videos, good material. You can get it provided you download our BYJU'S exam prep app. Very, very important. Unless and until you download our app, you will not get the full benefit out of it. So requesting each and every one of you. So how many of you have already downloaded our app and how many of you haven't till now? If you haven't, it's your duty today to download our app. Believe you me, you will get decent material, decent stuff over there, which is going to help you insofar as your preparation for these examinations are concerned. Okay, so there are a number of free videos which are there in our app. Just download the app. Moving on to the next topic, act of God. What do you mean by act of God? It is also a defense. It is also a particular defense. Now, what does this act of God simply mean? Now, suppose there is a natural calamity. Natural calamity, an earthquake, a volcanic eruption, a tsunami, a cyclone. Now, here we are dealing with certain situations. Here we are talking with certain situations which are not within the control of human beings. Do we have control over an earthquake? Do we have control over a volcanic eruption? We don't. We just do not have control over these events. Right? Now, these are all natural activity. These are all natural activity. Earthquake, is it not a natural activity? Yes. There is no human interference. So there is no human interference. Very important. And this is nothing but the fury of nature, the wrath of nature. Right? Let's understand what is given. Act of God. It's a defense based on the principle that liability must be founded on the fault and the person cannot be held liable for the fault that is beyond his powers. Now, if suppose, let me give you an example. Now, suppose I am into a construction business. Suppose I build a huge building. I build a huge building in Delhi. I take into consideration the soil, the weather, everything. Now, keeping in mind the surroundings, I build this particular huge building. Now, one fine day, what happens? There is a huge earthquake, something that Delhi has not witnessed in the last 500 years. 500 years, touch wood, it does not happen. Now, if that building falls, it breaks, it collapses, can I be held guilty for the casualty or the deaths or the injury that took place owing to that building collapsing? Can I be held guilty? Can I be held guilty? No, I cannot be held guilty because it is a natural activity, no human interference, and it is beyond my powers to control such an event. It is just beyond my powers. So, a loss that results from a natural cause without human intervention of a man, that could not have been prevented by the exercise of prudence, diligence and care, amounts to act of God. That is what is act of God. Have I been able to make you understand what exactly is act of God? Any doubt? And if you have doubts, we are having this marathon rounds. If you have doubts, let me know. So, act of God is a situation wherein there is a natural activity, no human interference, and it is the fury of nature, the ghost of nature. Okay? Is that clear? All of you? Any doubts? Okay. Okay. Let's move on. Up next is your slide, not mine. Read the principle, read the facts, give me the correct answer. The principle of act of God is very simple. I'm sure you understand that. It's a defense. Event is so exceptional and could not have been anticipated. Could not have been anticipated. Very, very important words. Exceptional circumstances could not have been anticipated in long history. Now tell me one thing. Tell me one thing. I'm sure you must have traveled to Shimla, Kulu, Manali, Nainital, Uttarakhand, all this, Spiti, Ladakh, what else? Right. Now tell me one thing, is landslide very abnormal in the hills, or do you expect a landslide generally? Tell me that. Is it natural to have some landslides Or is it once in 500 years it happens? Tell me. When you are in the hills, will it be absolutely shocking for you to know that there is a landslide? Or do you expect, oh, theek hai, some small little landslide happening here and there, it's okay. It's natural. We expect, right? Now, the bus driver is driving through regular mountain. He encountered what? A sudden landslide. Thereafter, the bus crashed into the car right behind it. Fair thought. What's the correct answer? Is it an act of God? It is not act of God. It is not act of God because this is very natural. It is but natural. Have I made my point clear? So, it is very natural for a person to expect a landslide in the hills. So, it is, if it is expected, then it is not act of God. So, the correct answer is only the bus driver will be held liable. Although it is a natural activity, no human intervention. Is that clear? Is that clear to everyone? All of you. Okay. Let's see. Act of God only relates to certain things that is unexpected, unnatural to happen. During monsoons, Kerala, you are going to get rain. Of course, it's a natural activity. All natural activities are not covered under act of God. Have I made myself clear to everyone now? All of you are understanding these classes? Great. Every one of you is giving me the right answer, and believe you me, if you know it, that's good. And I'm very proud of you guys. You guys are absolutely brilliant, and I'm sure most of you who are watching this particular show will definitely get through the top law schools of Maharashtra CET. Okay, definitely, if you're liking this session, do press the like button and do what? Share this session. You have to share this session so that this video reaches many of you who do not know something. Next topic: culpable homicide and murder. The next important topic is very important for you because you get a lot of questions from culpable homicide and murder. So what exactly is culpable homicide? What exactly is murder? Now, in both culpable homicide as well as in murder, there is a death of a human being. There is a death of a human being. So do not think that culpable homicide may, sir, there is no death. Murder, there is death. No. In both the cases, there is a death of a human being. Both in culpable homicide as well as in murder. What is culpable homicide? And how is it different from murder? Now, let me put it very simply. Culpable homicide, suppose this is a bigger set called culpable homicide, CH. There is a smaller set over here called murder. Did you understand? This is culpable homicide. Everything. Okay, everything. But this part is called murder. So there is a smaller set which is murder, and the larger set is the... So all murders are culpable homicide, but all culpable homicides are not murders. One line. Remember this. Now, how do we differentiate between culpable homicide and murder? How do we? And how is it different? The difference between culpable homicide and murder is definitely what Pallavi has said. It is called knowledge. The only difference between the two is called knowledge. And how is it? Now, suppose if you are doing an act, and you know that generally by that act, somebody would be killed, and that person is killed, case of murder. But you do an act and you think that no, generally a person would not be killed, but in exceptional circumstances might be. That is called culpable homicide. So in culpable homicide, you do not have the knowledge that by your action somebody would be killed. Whereas in murder, you have a situation wherein you are aware that by your action somebody might be killed. Somebody might be killed. That is what we understand by the difference between culpable homicide and murder. Let's read it. Section 300 deals with culpable homicide is murder. When is culpable homicide murder? If the act by which death is caused is done with the intention of causing death, except, very, very important, except when it is committed without premeditation in a sudden fight. Now, in the heat of the moment, you do something, somebody has told you something, in the heat of the moment, you slap someone, that person gets injured badly and he dies. So that is an exception. If there is no premeditated plan, very, very important. Unless and until there is a premeditated plan, it is. Now, in the heat of the passion, heat of the moment, you do something, somebody dies, it is not murder, but it is culpable homicide. So this is an exception. Sudden provocation, sudden quarrel, without the offenders having taken undue advantage or acted in a cruel or unusual manner. Another exception is when the situation culpable homicide is not murder. Let's see when culpable homicide is not murder. So culpable homicide is not murder if there is a heat of the passion, heat of the moment, you do something, there is an argument, you react suddenly without any pre-planned thing. That is what is called the difference. So knowledge is precisely the difference between the two. Let's move to the principle and the facts for question number 6 is up there. Please read it very carefully. Grave provocation, grave or sudden provocation, thereby causing death, it is an exception. A was deeply insulted by B when he suggested that A's mother engaged in promissory activities. Now, these are all immoral activities, okay? Under this grave insult, A got provoked and killed B, so he invited B to his house for dinner the next day. where he committed or killed him. So this is a premeditated, pre-planned. It is pre-planned because you are inviting someone else. It is not done on the heat of the moment. When someone tells about someone's mother, he will get furious. If he slaps someone and that person die, that is protected because at the heat of the moment. But next day, you are planning to invite him. You have indirectly invited him to your house, made a pre-plan that, okay, let him come. I am going to poison him to death. Now, that is not protected. That is not culpable homicide. So let's see. Okay, question number 6. Let's see the options. Is it murder? Is it culpable homicide not amounting to murder? Please tell me the answer. There is a premeditation. There is a pre-plan. You are inviting someone. You know that somebody has done something, has said something. You invite him to the dinner. And then you kill him. What is the answer? Is A guilty of murder? Is it so? Yes, it is. Option A is the right answer. Option A happens to be the absolutely right answer, guys. Okay. Any doubts? So guys, how many of you, before we move on to, there are many topics for the day and it's a marathon round, we have time on us. Now, can you tell me which are the topics in which you are finding it difficult to understand? Because in the previous session, we did vicarious liability. We spoke about murder and culpable homicide also in the previous session, right? This is the second part too. So if you have any general doubt, sir, what is the difference between kidnapping and abduction? I could not understand, sir. Something like that. I can explain to you. So if you have any pertinent doubts in your mind, you can definitely ask me. And I will be more than happy to help you because this is an initiative from BYJU'S Exam Prep to help students because we believe in the concept of helping the next generation to become the stars because you are the next stars of the country, the next leaders, the next politicians, the next lawmakers, the next judges of the country. Okay. Yeah. Contract, constitution and legal GK, offense. Okay, contract. What in contract? Could you just tell me? We are going to talk about wagering agreements and indemnity today. Okay. Okay. So, okay, I'm not getting some specific doubts. Somebody says contract, I'm always confused while answering. So I cannot, so if you have any particular doubt, okay, this session is sufficient. Yes, these sessions are good for your preparation. Now, legal GK. Now, legal GK, they do ask you good amount of questions on legal GK. And these are something that you have to learn. For example, they might say, what is advisory jurisdiction? What are the different types of writs? Fundamental rights is given under which part of the Indian Constitution? Which part of the Indian Constitution deals with fundamental rights? Which part of the Indian Constitution deals with directive principles of state policy? They might also say, they might give you a question on some recent topics. Uniform Civil Code, it's on debate. So, a student must be aware and beware of the recent incidents that have kept on happening in the legal scenario in our country as well as across the world in the last 1 year. That is the most important thing. If you have read the newspapers well, if you have prepared yourself well, then it is not difficult at all. Okay? Attempt. Now, what is attempt? Attempt means, suppose there is a person I want to kill. Okay? Attempt. Suppose there is Mr. A, I want to kill Mr. A. I have a knife in my hand. This is a, suppose think this is a pen, but think it is a knife. The moment I throw the knife, even if that knife does not touch Mr. A, that knife has never touched Mr. A, but there I have attempted to kill him, that is called an attempt. Even if it does not touch him. Now, void and voidable contracts. Okay. Now, void and voidable contracts are two different things. Let me just tell you. Now, void contracts are those contracts where there is an illegal object, an illegal consideration in it. Suppose an agreement between a minor is void. Agreement to do something illegal, it's void. Now, what is voidable? Voidable is a situation where one party is not exercising his full liberty or right when he is giving consent. For example, coercion. Suppose I tell you, sign this contract. You don't want to sign it. But what do? I place a revolver on your forehead and I say, now will you sign this document or not? You are forced to sign it. Voidable. Undue influence owing to the position that a person has. You are occupying a particular chair. You take advantage of it. Undue advantage. Then you have fraud, you have misrepresentation, and then you have mistakes. So this renders a contract voidable. But if you do something illegal, you are entering into a contract to sell a person. Selling of human being is not allowed under the law. That is void. Am I clear now? Have I made myself clear? Okay. Let's move on. Let us move on. Okay, the solution. Culpable homicide is not murder when it is under provocation or grave threat. But that is not so. Answer is A. Okay, are we done? Let's move on. The concept of necessity. This also is a defense under law of tort. This also is a defense under law of tort. Now, what does this defense deal with? Let's understand that. Now, what is necessity? Anyone who knows or can give me in a small 2 lines what is necessity? Can anyone? Can any one of you tell me right now what do we mean by necessity? Let me give you an example and you will understand it better. Necessity simply means that to control or to prevent a larger harm, from happening, you commit a smaller harm. Very important. To prevent a larger harm from happening, you are causing a small harm. Let me give you an example. I am very bad with my drawings, okay? Suppose there is a house over here. This house, this particular property belongs to A. This property belongs to B, and B has a lake, a pond containing water. Now, suppose this particular house, which belongs to A, catches fire. There is a fire in Mr. A's house. There is a fire at Mr. A's house. So what does Mr. A do? Mr. A enters into Mr. B's land. Mr. A enters into Mr. B's land without Mr. B's permission. Is it not trespass? It is. It is trespass. So A has committed trespass on Mr. B's land. Now, when B sues A for trespass, what will Mr. A say? What will be the argument of Mr. A? His argument will be, to prevent a greater harm, he has committed a smaller harm. So, fire in this house, there is a fire in the house, so he enters into someone else's land, and what does he do? Simply pick a bucket of water for stopping this fire. That is exactly what we understand by necessity. That is what we mean by necessity. To prevent a larger harm, you are committing a smaller harm. Is that clear in your mind? So necessity will act as a defense. Necessity will act as a defense in these kind of situation. Okay? These are the acts which would have been unlawful otherwise. But due to the defense of necessity, this is an exception. This is an exception to the rule. Have I made myself clear? Read it. Okay. Yes, he is trespassed because of necessity. That is what? Imtiaz. Okay. Okay. All of you? Clear? Everyone? Any doubts? Fantastic. Fantastic. Brilliant. This slide is only for you, not for me. You are preventing a bigger damage from taking place. You are preventing a bigger damage from taking place. That is the philosophy behind necessity. I don't think I have to tell you the answer. Do I have to tell you the answer? Do I really have to tell you the answer? Very good. Each and every one of you have given me the absolutely right answer. Brilliant. Lovely. Lovely. So, I see you guys are very well prepared. So, do not be under any stress. You have done a good preparation for yourself. Expect good results. Pay your full attention in the class. You have done it all throughout. Give your exam and expect for a good result. That is all that I would want to say. You guys are giving me really good answers. You guys are understanding, and I am really lucky to have such students like you. Very good, very good. Tejasvi sir, in exam only paragraph based questions will be asked, or one liner based questions? You are not going to get passage based questions which come in CLAT. In your Maharashtra CET examination, the kind of questions will all be principle and fact based question. Apart from the principle and fact based questions, you should also be expecting legal knowledge or constitutional knowledge based questions. Is that clear? Have I made myself clear? Okay. Somebody scored 99 in his previous mock. Very good. Congratulations. Moving on. Okay. Any doubts? Any questions? Yeah. Any doubts? Any questions? Are your videos enough for legal reasoning? I think nothing is enough in this world in competitive examination. Your preparation, your skills, your aptitude, your confidence, your street smartness all play crucial role. See, in a competitive examination, we cannot spoon feed you. We cannot spoon feed you. Okay? Now, all the thing that we can do is that we can explain to you certain principles. Now, if you understand and how to apply while answering a question, it depends on your skills. I cannot teach you how to read English. I expect you to read English, right? So, please have a cool mind when you are answering a question. Remember one thing, that there is a time. You have to answer X number of questions in Y amount of time. Do have that time management also inside you. That is going to help you. So all that we are at BYJU'S exam prep trying to say is that your preparation must be at par with the fact that you should get into the top 2 or 3 law schools in Maharashtra CET, and they are ILS Pune, GLC Mumbai. I want each and every one of you to get through GLC Mumbai and ILS Pune. Okay? Okay. Sorry. The next important principle that I'm going to talk to you about is called dowry. The concept of dowry death, very important insofar as your exam is concerned. So what exactly is dowry death? Now, let me give you a small brief idea about the concept of dowry. Now, in India, there happens to be this particular practice. It's a practice. During marriage, it's a particular practice that during marriage, the wife's family gives certain things to the husband's family. Okay? Bed, sofa, TV, refrigerator, bike, motorbike, aeroplane, not an aeroplane, just joking. Okay. So there is this custom. Now, without demand, if my wife's family wants to give me something, that is not dowry. That is not dowry. What is dowry? Understand the thin line difference. It is when you are demanding something. Suppose I tell, give me an aeroplane, give me a motorbike, give me a flat, give me this. That is dowry. But if you haven't asked for something and your in-laws are giving you a golden ring, that is not dowry. So that is the difference. Are you demanding something or are you not? Now, dowry is a system which is predominantly in the northern belt, Bihar, Uttar Pradesh, Madhya Pradesh, Delhi, Haryana, Punjab, Rajasthan, Gujarat, Chhattisgarh, this area. Eastern part less, southern part also less. Now, let's understand what dowry is. So, in case there is a demand for any movable or an immovable property from the husband's family to the wife's family, that is called dowry. Now, over the years, we have seen a married woman being subjected to cruelty because the demands of the husbands were never fulfilled. So here is a condition where the demands of the husband is not fulfilled by the wife's family, and that's the reason why a wife is tortured physically, mentally, whatever. And owing to this torture, at times women died. For which reason the Indian laws come into being, which says that what is dowry death? Now, if a woman dies within 7 years of her marriage, very, very important. If a woman dies within 7 years of her marriage, owing to an unnatural reason, a heart attack, it can be a heart attack, right? So if a woman dies under unnatural circumstances like burns, bodily injury, so there is a death owing to burns or bodily injury within 7 years of the marriage, within 7 years. 7 years is very, very important. And before the death, before the woman dies, she was subjected to cruelty. Why? Because the demands were never fulfilled. So the fact that the demands were never fulfilled by the wife's family, there was cruelty, there was torture, there was harassment being put forth against this particular lady who got recently married within 7 years, and she died. And before her death, soon before her death, she was subjected to cruelty by the husband or the husband's family in connection with demand for dowry. Now, suppose I'll give you an example. Mr. A slaps his wife very badly. Suppose Mr. A's wife did not cook something which Mr. A wanted. In the night, the husband slaps the wife and the wife dies. Is it a case of dowry death? Is it a case of dowry death? 7 years, the death happened within 7 years, unnatural circumstances. Is it a dowry death? No, it is not. Because there was no demand of dowry. There was no demand of dowry. So unless and until there is a demand of dowry, it cannot be a dowry death. Right? Such death will be called dowry death, and the husband or the relatives will be deemed to have caused the death. Punishment under this section is imprisonment for not less than 7 years, which may extend to life imprisonment also. So this is what dowry death is under the law. Am I clear? Okay. Domestic violence is something else. Domestic violence is something else, Saloni. Read. So a woman dies because there is a fire that has been caught in the house. Now, the woman dies within 7 years of the marriage. Within 7 years of the marriage. There is a death of a woman within 7 years of the marriage. It is an unnatural circumstances. But was there any demand of dowry? Any demand of dowry? If you tell me the answer, that's the answer. Was there any demand of dowry from the husband side? There was no demand of dowry. From where in the facts do you say that there is a demand of dowry? So since there is no demand of dowry, it cannot be a dowry death. So the correct answer is okay, all of you. Is that clear to everyone? Now, before moving ahead, let me just remind you once again what I said around half an hour back. Guys, if you are really interested to get into the top law schools of the country, there is a simple way out. And that way out is download the BYJU'S exam prep app. There is good amount of recorded videos, good amount of material, good amount of question answers, which is absolutely available once you download our BYJU'S exam prep app. So what are you waiting here for? Just download it. It takes very less amount of internet to just download an app, right? It's a very simple app. Just download the app and everything. You will get a huge, good amount of material, question answers, quizzes, interaction with the faculty, everything. But for that, you have to download the app. Is that clear? Okay. Any doubt? So the correct answer is option B. Option B. Is that clear to everyone? Any doubt, you can ask me. If you have any serious doubt, most welcome to ask me. Okay? Okay. Fantastic. So you guys are enjoying this class as I am? I'm sure you guys are. Right, fantastic, great to see that. Yes, moving on to the next topic, that is indemnity. What do we mean by indemnity under law of contract? What is indemnity? What exactly is indemnity? Can any one of you tell me? Now, indemnity is something wherein a loss can be protected. A loss is protected. Now, Now, what do you mean by a loss that can be protected? What do you understand by the fact that a loss can be protected? Now, suppose I fear that my house might catch fire. You might fear. You think, okay, in case my house catches fire, I will suffer a huge loss. Huge loss. I want that loss to be protected. You go to an insurance company. What do? You go to an insurance company and tell him that, Mr. Insurance Company, I fear that my house might catch fire. I will give you an EMI or a premium. Every year I will pay you 8,000 rupees. Provided you guarantee that in case, in the event, my house catches fire, you shall bear the losses. Brilliant. In case my house catches fire, the loss that I will suffer will all stand protected by the insurance company. That is precisely what we understand by indemnity. So you are protected from the losses that you might suffer. Another example, car. If you buy a car, you have to get accident insurance, first party insurance, third party insurance. What is that? So suppose when you are buying a vehicle, a four-wheeler or a two-wheeler, it is mandatory under the law to have insurance of the vehicle as well as of the parties. So what do you enter into a contract with the insurance company? You say, car insurance. In case my car meets with an accident, or if I am injured, or if some third party is injured by the accident, hospital charges, medicine, car damage, everything shall be protected. Everything shall be protected. That is precisely what the concept of indemnity is. It is a kind of a guarantee that in case you suffer a loss, that loss will be protected. Have I made myself clear? Read. Where one party guarantees to save the other from losses caused by him by the action of the guarantor himself or by the action of any other person. In accordance with various developments by way of landmark judgments, the recent position of losses in indemnity is limited to exclude losses caused by accountable body's negligence. Now, if there is a negligence, now, suppose you drink alcohol, you are out of your senses and you start driving a vehicle. You meet with an accident. Will the insurance company bear for the loss that you have suffered? No. Suppose you know that your vehicle, the brakes are not working. You have taken that car out. That is not covered under insurance. Keep that in your mind. Keep that in your mind. Have I made myself clear, everyone? So, it is very, very important. Because of your negligence, something wrong happens, insurance company is not liable. A contract of indemnity can only be invoked when the accountability body has made reasonable endeavors to recover reclaimed grant from the relevant project management, including legal action. So, Medical insurance. What does medical insurance mean? In case I suffer from a particular disease, or if I have to have a surgery, if I am not well and I am admitted in a hospital, the amount of money that I spend in the hospital will all be given back, and whatever I have spent from my bank account will all come back. Simple. As simple as that. Is that clear? Is that clear to everyone? That is the precise concept of indemnity. Have I made myself absolutely clear to each and every one of you? Please. Somebody saying your video is buffering. Is the video buffering? Tell me that. Understand it. So guys, do like and share this particular session with your friends so that people at large can be beneficial, because this thing we want to be a benefit for everyone. There is a mixed reaction. Some people are saying no buffering, all clear. Some people are saying buffering. So I would just say that no, there is no buffering right now because I'm in the office and we have great internet out here. Okay. So I'm in the office and it's a great internet out here. I think there is some problem owing to some rain or the monsoon season, owing to which there might be some buffering at your end. Okay. Okay. Chalo. Let's move on. Question number 9 is up there on your screen. Sir, yeah. Explain once again. Okay. After this, I'll come back to explanation. First, tell me, because only one person has said, Krishna Gandhi has said, please explain. I'll explain it once this particular answer is over. What's the correct answer? Not a difficult answer at all. A substandard truck. That means negligence. You know that the truck is not great and you want to send it for a long journey. You are asking for some trouble for yourself. Indemnity will not be made applicable. Indemnity is where you have taken all precautions. You know very well that you have a brake problem, you have some clutch problem, your gearbox is not functioning properly, you meet with an accident and then you claim insurance. Is it possible? Okay? Is that clear? Have I made myself clear? Everyone? So indemnity means to make good the losses. So if you think that there exists a situation wherein you might suffer a loss, you can protect yourself from those losses by indemnity. Indemnity is a situation. It is a method whereby you are trying to protect yourself from the losses that can crop up in future. Anybody, I can meet with an accident. I can be hospitalized tomorrow. So to prevent myself from those losses, I am entering into this agreement with an insurance company. As simple as that. Have I made myself clear, everyone? Is that clear to everyone? So guys, if you're liking this session, do press the like button. Do press the like button. Okay. Let's move on to the next important topic of discussion. Answer D. No problem. And the next topic is wagering agreements. Very important. Very important. Now, what is a conditional contract? So the real thing is called conditional Now, what is conditional contract? What do we mean by conditional contract? So, there are certain contracts. There happens to be certain contracts which are based on a future event. When I say, if you score 10 out of 10 in mathematics, I will give you 100 rupees. When can you ask that 100 rupee from me? When can you ask that 100 rupee from me? Only after you score 10 out of 10 in mathematics. Only after you score 10 out of 10 in mathematics, you can ask that 100 rupee from me. Suppose I say, if you get into GLC Mumbai, I will give you 10,000 rupees. Example. When can you claim that 10,000 rupees? Only after you have cracked GLC Mumbai. So there are certain terms and conditions that you need to fulfill before you are executing the contract. For example, another example, if you can climb Mount Everest, I will give you 10 lakh rupees. I will give you 10 lakh rupees only if you can climb Mount Everest. So, you have to climb Mount Everest before claiming that 10 lakh rupees from me. Am I clear to each and everyone? That is called a conditional contract. Now, conditional contracts are absolutely legal and enforceable in law. Now, let's come to wagering agreement. Now, what is a wager? A wager is a bet. I'm sure you must be hearing those terms called, what is it called in Hindi? Satta, jua, betting. Any other Hindi terms that will be familiar to you? I'm just using those terms. So, what is betting? Gambling. Have you heard about gambling? Betting, satta. Somebody says that, you put in money in this, you put in money there, bet. Bet. That is what is the concept of a wagering agreement. So let us try to understand this particular thing. What is a wager? I'm sure that you know about teen patti. Teen patti. A, B, C and D. There are 4 people, A, B, C, D. They want to do something like a gambling. So there is a deck of cards, a pack of cards. There are a deck contains 52 cards. The cards are shuffled properly, mixed properly. So the cards have been mixed properly. After having mixed those cards, one card is given to A, one card is given to B, one card is given to C, one to D. Then another card to A, another card to B, another card to C, another card to D, another card to A, another card to B, another card to C, and another card to D. Three cards, 4 of them got it. Now, does B knows which card he is going to get? Does B know which card he is going to get? Does the person who is giving the cards know which card is going to whom? Does the person who is distributing the cards know which card has gone to whom and which card has not gone to whom? No. So, suppose A is a 50-year-old man, 50-year. D is a 5-year-old boy, 5-year. C is a 25-year-old man. B is also a 50-year-old man. This 5-year-old boy does not know anything. He might only know A, B, C, D. 5-year-old. Do you expect a 5-year-old to know mathematics? No. Now suppose A gets 7, 8 and a king. B gets a 6, an 8, a 3. C gets another king, a 10 and a 4. And D, who happens to be a 5-year-old boy, gets ace, ace and ace. Who is the winner? Who happens to be the winner? Who is the winner? 5-year-old boy. The 5-year-old lad becomes the winner. How? How did D become the winner? How did D become the winner? Tell me. Luck. Taqdeer, taqdeer, luck, luck, luck. Hindi, yeah. There is a luck that is involved. So the 5-year-old kid becomes the winner not because of any talent, not because of any skills, but owing to the fact that his luck was good or better than the rest. He had a better luck. There is no talent involved. Mind you, is there any talent involved? No, there is no talent involved. It is by chance, by luck, or by chance. It is a pure case of a luck or a chance, whichever you agree. That is called betting or a wagering agreement. Either by luck or by chance, someone gets everything in a platter. Now, that is what we understand by a wagering agreement. Wagering agreements are those agreements entered into between parties where money is payable depending on the happening of a non-happening of a future event. And another very important thing, remember it, is there is no skill involved. Where there is no skills involved, a situation wherein there is no skills involved gives rise to a betting or a gambling situation. Have I made myself clear? lottery, horse racings are an exception to the rule. Horse racing and lotteries are by the government, okay? Meghalaya government, Orissa government or state government are coming out with lotteries. That is legal. There are, see, everything I cannot explain you in the class. There are certain exceptions to the general rule also, okay? There are certain exceptions to the general rule also. Am I clear? Have I made myself clear, everyone? So guys, do not forget to download our BYJU'S exam prep app. That's a mandatory for you. You will get a number of videos over there, so do not forget. And do like the session, do subscribe to this channel if you have not yet done it. If you have done it, then share this video, but definitely subscribe to this channel, because this we bring to you very, very informative sessions for various law entrance examination. Okay, and an agreement by wager is void under the law. Okay, what are the essentials? It is independent on an uncertain event. Who is going to win, A, B, C or D? Everyone has equal chances of winning and losing. It is an uncertain event. Neither of the parties have control over the event. Do you know which card you are going to get? Does B know which card B is getting? Does C know which card he is getting? No. There is no other interest other than the money involved or the stake that is involved. Other than the money that is involved, there is no other interest. There is no other interest. Okay? So, I'm so sorry. Okay? All these things done? Everyone? The agreement is void means that agreement does not exist. You cannot, suppose you have won 500 rupees by betting, you cannot go to the court and claim the money. It's illegal. Question number 10 is up there on your screen. You are not required to by heart fundamental rights or any section for that matter. Okay? Please do not learn or by heart any sections or any particular article. It's not expected from you. Does it look like a wagering agreement? Or is it a conditional contract? Insurance. What does the facts look like? Does it look like a betting, or is it something like an insurance? Tell me. It is not a wager. It is not. Now, suppose you buy a vehicle, a BMW vehicle, which is coming from some other country. It's a very pricey, very costly vehicle. You want that it should not suffer any loss. Now, in the high seas, there can be a storm or a tempest. In Shakespeare's words, there can be a tempest. So, you want protection from a particular loss. You want protection from the loss. So, is that clear? Is that clear to every one of you? It is a case of an insurance. It is a case of a conditional contract. Nothing more, nothing less. Am I clear to everyone? Okay. So guys, do share, do like this video, and that is the only thing that we can expect from you guys. We are doing it free of cost in the YouTube channel. It's only the thanks. If you want to thank us, just your like, your share, and your subscription to our channel is very, very important. Just subscribe to this channel. It's a beautiful channel, believe you me. Okay. So, indemnity is a type of a conditional contract. Nisa Norin. Nisha, indemnity contract is a kind of a conditional contract. Okay. Okay. Any other doubts that you have in your mind? Okay. Any other questions that you have in your mind? Okay. So the correct answer is option A, contract. All of you. Okay. So with this, sorry, guys, with this, we come to the end of this marathon part 2 for Maharashtra CET legal reasoning. I hope that the topics that we have discussed, starting from partnership, divorce, gift, dowry death, culpable homicide, murder, necessity, wagering agreement, indemnity, private defense, act of God, I think you have understood this. So guys, with this, we come to the end of this marathon session. I hope you understood the topics that we have discussed with you in detail. Thank you very, very much for being such a great listener, for this amazing students who have watched me. Thank you very, very much. I wish you all the very best for your examination. Do well, succeed, and that is how we want to be thanked. If you succeed, we succeed. If you do not succeed, we do not succeed. Thank you very, very much. God bless you. All the very best. Stay strong. Do not think that you are less prepared than the other. You should have good confidence in yourself, and only then you can crack this examination. Think that you have done everything to get into the top law schools of the country. Only then you will be in a position to succeed. Okay? So with these words, we come to the end of this session. Thank you very, very much. God bless you. All the very best. Do well. Thank you. And my best wishes for each and every one of you. Thank you. Bye-bye. Take care. All the very best.